for this occasion, said it was indeed one of the saddest incidents that he's ever seen. There's the president waving goodbye, and you hear the applause.
Hello, my name is Brian McCann, and I'm starting a new series called This Week in American Legal History. And the point of this video is going to be once weekly. I'm going to drop a video on a case that took place during this week sometime in the past. So the point is going to be a little bit longer of a video, ideally between 8 and maybe 12 minutes. And it's going to go over a landmark case. Maybe it's a state Supreme Court case or a Supreme Court case, and just bring up some interesting facts that you may not know. So I'm putting a lot of work into this. If you can please subscribe to my channel, so that way you can keep updated to when these drop. This is a labor of love for me, and I really would appreciate it. Now that that's covered, the first case we're going to get into seeks to answer the following question. Can the President of the United States decide they are going to ignore a court order? Can the most powerful politician, the most powerful leader on the earth, look at a judge and say, no? Today, some would argue that seems unthinkable. Some would argue that it's happening. But in the summer of 1974, that very question put the United States on the brink of a constitutional crisis. So this week in American legal history, we are going to look at the landmark United States Supreme Court case, United States versus Nixon, which was decided on July 24th, 1974. To understand the case, you have to go back in time 2 years to July 17th, 1972. 5 men are arrested breaking into the Watergate complex, home of the Democratic National Committee. At first, it looked like a peculiar burglary. But federal investigators and reporters, most notably Woodward and Bernstein, keep going hot on the trail and trying to uncover what was really behind that bizarre break-in at the Watergate complex. What they found shocked the world. Money trails, political espionage, a cover-up. Eventually, investigators began asking a dangerous question. How much did the president know, and when did he know it? Here's an interesting wrinkle. President Nixon recorded everything that went on in the Oval Office, and I mean everything. Cabinet meetings, phone calls, personal visits. He thought that the recordings would create an accurate and complete presidential record. Instead, they helped create one of the most important evidence trails in American presidential history. The special prosecutor of the Watergate incident wanted those tapes.
In these folders that you see over here on my left are more than 1,200 pages of transcripts of private conversations I participated in between September 15, 1972 and April 27 of 1973 with my principal aides and associates with regard to Watergate. As far as what the president personally knew and did with regard to Watergate and the cover-up is concerned, these materials, together with those already made available, will tell it all.
So what did he do? He subpoenaed for them. Next thing you know, Nixon refused. The reason Nixon refused is something called executive privilege. Now, executive privilege is a pretty simple constitutional principle. A president needs confidential communications in order to do their job. Not everything they do can be out in public. They're dealing with foreign affairs. They're dealing with issues of national security. They're dealing with issues that could impact the lives and livelihood of everyday Americans. And so if every single thing that a president said in a closed-door meeting became public, that's going to hamper and take away the ability of future presidents to do their job well. No one disputes that having some presidential communications remain private is absolutely a part of the function of the executive and not subject to discovery, especially while they're president. But here's the key legal question, and here's the legal question which United States versus Nixon sought to answer. Is that privilege absolute? Can a president invoke that privilege whenever they see fit? And if so, what are the limits? That is the question that landed before the Supreme Court. So as to the legal issue, it is important to distinguish. The court was not deciding whether Richard Nixon was guilty or innocent. That was not what was before them. It also wasn't deciding whether Watergate happened or didn't happen. That was not before them. The issue was actually much more narrow. The court was trying to answer whether a president could refuse to present evidence once subpoenaed by exertion of executive privilege. The court wasn't above politics. It was above one political figure. When it came time to the decision, on July 24th, 1974, the Supreme Court issued one of the most significant and consequential decisions in the history of the Supreme Court. The vote, 8-0. This crossed partisan and ideological lines and was unanimous. Importantly, Justice William Rehnquist declined to participate because of his prior work with the Nixon administration. Chief Justice Warren Burger wrote the opinion. The court unanimously recognized that executive privilege does indeed exist. But, and this is important, it is not absolute. When there's demonstrated need for evidence and a criminal trial, the rule of law prevails. Not politics, not power, not even the presidency. The court ordered Nixon to surrender the tapes. What happened next was extraordinary. The tapes were released. Among them was what became known later as the smoking gun tapes. It showed conclusively that Nixon was directly involved in trying to obstruct the FBI investigation just days after the Watergate break-in. For Nixon, his political support collapsed almost overnight. Just 16 days after the court's decision, Richard Nixon became the first, and so far only, United States president in history to resign. This case matters because it really isn't about Richard Nixon. It's about something much larger. Can anyone be above the law? The Supreme Court answered no. Not a governor, not a senator, not even the President of the United States. That's why you still see United States versus Nixon cited in constitutional cases. Because whenever a question of executive power is asked, this is the benchmark. It reminds us that constitutional government requires accountability and oversight from the legal system. A few interesting facts about United States versus Nixon. First, the court moved incredibly quickly. The case was argued on July 8, 1974, and decided just 16 days later. Second, Nixon himself had authorized the White House taping system, believing it would help him preserve his legacy. Ironically, the very system meant to preserve his legacy was the cause of his downfall. Third, this was not a liberal versus conservative or a Democrat versus Republican issue. The opinion was unanimous. The judges understood that the principles they were deciding went beyond party lines and ideology and were rather core to the idea of what it is to be an American. One of the things I love about studying legal history and large landmark cases from legal history is that the cases that are the biggest and that resonate the longest usually are not trying to answer complex or complicated questions that we can't understand. Usually it's the simple questions that courts answer when they make the biggest splash. Things like, can the government search your home and how? Can speech be punished or regulated or stifled? Can a president ignore a subpoena? The answers define the country that we live in. And 50 years later, United States versus Nixon remains one of the clearest reminders that in America, the Constitution, not any individual, is supposed to be supreme. I'm Brian McCann, and this has been This Week in American Legal History. I hope you like it. Please like, subscribe, and share.